Law of Evidence, Presumptions, Part 1, Presumptions of Facts. What are presumptions? Presumptions is a legal principle that states the party relying on it must first establish certain basic facts, exist before the presumptions can be used. Presumptions of law are rules of evidence that affect how a fact in issue is proved, and most presumptions are rebuttable. An argument of a fact from a fact based on previous experience and based on circumstantial probable evidence that entitles it to belief. Rules for presumptions of facts under the Evidence Act 1950. It enables the court to presume a fact until it is disapproved. Here are the other sections regarding presumptions of facts in our Evidence Act 1950. Court may presume existence of certain facts. Presumption is a legal principle that governs how conclusions are drawn. It is a unique way of establishing facts that would ordinarily require evidence. Presumptions of fact and the inference of particular facts patterns based on experience, observation of common course of nature, human mind's composition, the springs of human activity, and society's usage. Therefore, court judges' discretion to invoke the presumption and fact shall be presumed unless disproved otherwise. This is the case law based on presumptions of fact, which is Muhammad Hassan versus Public Prosecutor. The ruling in Muhammad Hassan revised the Dangerous Drugs Act, which allows presumption to be applied in conjunction with the presumption against an accused person. However, the presumption was not rebutted because the accused did not present any evidence in rebuttal. I believe that the method of presumptions is primarily utilized to relieve a party from having established a veracity of fact being presumed. When one party relies on a presumption, the opposing party is usually entitled to present the evidence to contradict the premise. This is beneficial in terms of faster and more reliable applications to criminal situations such as drug trafficking, investigating murder crimes where factual presumption serves a strong starting point. A rebuttable presumption is one that can be refuted by factual evidence. Furthermore, I believe that evidence is sufficient because an experienced and knowledgeable lawyer or officer is able to present facts to persuade the judge.
Next, we are moving on to the presumption of law. Under this presumption, legal reasoning may not be based on logic entirely. Instead, human logic or reasoning is controlled by the law. Such legal reasoning may sometimes be illogical to the human mind, especially when considering the conclusive or irrebuttable presumption of law. Conclusive presumption. The consequences of this is that the law disallows the inference to be defeated and it is absolutely conclusive at all times. Meanwhile, rebuttable presumption denotes a conclusion that must be drawn by a court on proof of the basic fact of the presumption unless the party disputing it disapproves the conclusion. This case discusses on the legitimacy of a child under Section 112 of the Evidence Act 1950. It is also not in the best interest of the child to allow the DNA test as it will disrupt the child's life. The Court of Appeal added that the High Court had erred in its undue preoccupation with the supposed fears of illegitimizing the child. In Section 112, as an attempt to curtail such declarations, the presumption under Indian laws was incorporated into Malaysian Evidence Act. As for Section 113, although a child cannot be convicted for rape, they can be charged and convicted for assault. In a simpler manner, presumption of law may be absolute control of law where no human logic or reasoning can be invoked. Hence, inclusive presumption of law is a substantive rule and not part of the law of evidence. For example, the age of criminal liability. Rebuttable presumption, however, is a procedural rule that defines the relationship between two facts. If the basic fact is proved, then presumed fact must be accepted as established unless and until rebutted.
Created using Powtoon.